Welcome everyone to our Codex group meeting. It's Thursday, 1:30, and we're excited for you to join us. We have a presentation today by Pat Wilburn and Dave Contreras. Pat is the CEO of Predict.Law, and Dave is the CTO. And Predict.Law is a legal analytics platform that is specifically focused on personal injury cases. And so we're thrilled to have you. So with that, just one more quick announcement, maybe. So we'll be traveling. That is Robert Mahari and I, our associate director, and I will be in Davos, where Robert is organizing and hosting an event that Codex is co-sponsoring, and so there won't be any meetings in the next 2 weeks. So we'll be convening again in early February. But okay, so with that, I will turn it over to Pat.
All right. Well, thank you, and it's nice to meet, at least virtually, all the folks on the call. Just a quick introduction on myself. I, along with Dave, are the co-founders of Predict.Law. Very, very briefly, prior to us launching this company, I was the chief strategy officer for Thomson Reuters. I think most folks know TR is probably the largest player in the legal tech industry, and part of that spent a number of years at Microsoft. Why did we launch this company, and what problem are we trying to solve? So we focus on the personal injury space. The inception story behind why we launched Predict.Law was we looked at the $61 billion of case value every year in the US from personal injury cases, and started to ask some what we thought were pretty basic questions to attorneys around the country, which is for that $61 billion in annual case value across these personal injury cases, how do you actually determine what a case is worth? And what we found were the answers we got back were, in our view, surprisingly legacy. For example, plaintiff firm in Seattle, mid-sized firm, said, I normally walk down the hallway and brainstorm with my colleagues. The owner of, I think, the largest PI firm in Maryland said, well, I tend to rely on my own memory. So this case feels like a case from 7 years ago. It's similar but different. It's kind of human heuristics model. And of course, you hear from folks who are using sort of legacy tools where, you enter in some search terms and receive a bunch of links with your precedent cases. It kind of feels like web search circa 1998. We determined from all of these conversations that there must be a more modern AI native way to approach this core question. And so what I'll show you here is a demo of the Predict.Law platform, which fundamentally is an AI native platform that helps attorneys and law firms very efficiently understand the value of their case based on north of 20,000 precedent cases, and then automate through data-driven workflows the process of handling and monetizing that case on behalf of their client. Let me share my screen.
Yes.
Hey, come in.
Okay. Maybe just a quick hand raise that folks are seeing my shared screen, and then we'll
That's good, Pat.
jump in. Thank you so much. Okay. This, as I'm sure you've assumed, is the home screen for a attorney and/or their support staff when they've logged into the Predict.Law platform. What you immediately see is a list of all the cases that are active in this firm. Of course, the case names, the jurisdiction, the timestamp, but importantly, the likely value of each of those cases. As well as you can see on the far right, if a demand letter has been created on our platform as well. The reason we created a summary view on the top of the home screen is we heard feedback from a managing partner, I believe, in New York, who told us, my law firm is also a business, and I have the same revenue pipeline and revenue tracking needs as any other business. And because the Predict.Law platform knows and understands the value of my case, you're also in a unique position to tell me how I'm tracking against my revenue goals as a firm. And so that top view, in this case, you can see this firm we're using in this example has 11.6 million in case value that's active in their pipeline. Let me show you what an actual case looks like. I'm going to go to start a new case. We've heard overwhelmingly from attorneys that they prefer to use existing case documents whenever they can, as opposed to manual entry. And so in this case, I've got a case for a new client. Her name is Emily Roberts, and I have an intake document. I have medical records and a fixed report. We can handle up to 10 documents, up to 100 pages per document, 1,000 pages in total, and very quickly, as you'll see here, be able to understand in about 5 to 10 seconds the most relevant information from those documents to determine the fact pattern of this case. In this example, our client is Emily Roberts. The defendant is Charles Mason. Jurisdiction for this case is Miami-Dade County in Florida. Our model trains on and predicts at the jurisdictional county level based on primary law from the counties. Just a bit of context, which will matter as we move through this case. You'll see this case dates to January 2025, in which our client was injured, in this case, in a motor vehicle accident where the defendant driver was operating in the course of their employment for Walmart. This is a fictitious case to show you what an example looks like. That will matter because as you move down here, you can see one of the questions we asked and have automatically pulled out from the case documents was the defendant operating a commercial vehicle or performing a commercial work function. All the questions we ask have been informed by interviews with practicing PI attorneys on the questions they ask in order to understand the likely value of a case. You can see in this example, there are no punitive damages likely based on the fact pattern thus far. Age and gender, and in this case, because it's motor vehicle, motor transportation, are all captured as well. We find those to be minor predictive attributes in terms of case value. For example, the award potential for a minor who's been injured may look different from an award value for an elderly person or an individual who was a pedestrian versus being in a vehicle. What tends to drive more material weight in the case value is the injuries. And so let's just spend a moment talking about the injuries in this case and how we use those injuries. And so in this case, again, our client, Ms. Roberts, has suffered fractures to her ribs. She has a pulmonary contusion. That's, of course, a lung bruise, and an L4, L5 disc injury. And importantly, I'll come back to this later, a type of nerve injury called radiculopathy, which you can see here. What we do with this information is important. One, we pull out all the areas of the body that have been injured, which matters in terms of showing you similar precedent cases. But secondly, we create two injury severity scores based on an American Medical Association injury severity scoring guide for every case. The reason we produce two scores, one is for the current impact of the injury, the second score is for the ongoing life impairment of the injury. For example, if a client had a fractured shoulder as a part of a claim, but with prompt and appropriate medical care, should experience a full recovery with no ongoing life impairment. It's a very different case and a very different award value than perhaps a client with a compound leg fracture who, despite prompt and appropriate medical care, will experience an ongoing limp or a gait in their walk. And so every case is assessed against its near-term and long-term impact on the injuries that they have suffered. I'm going to leave medical and lost wages blank here in order to make the point that often when a case is first being evaluated by a firm or an attorney, the case is not far enough along in its chronology to have a firm view on medical expenses or lost wages. That's okay. What we do is we interpolate what are called the direct or the special damages based on the remainder of the fact patterns surrounding this case, and then importantly allow you to go back in later and create versions of this case to update the facts as medical and lost wages arrive and are available, to allow you to always update and revise the award value of your case as more information becomes available. I'm going to move quickly and hit predict case here. What's happening here, this takes about 10 seconds, is we're doing two things. One, we are evaluating the fact pattern of your case against the relevant cases across 20,000 plus precedent cases, about 200,000 plus data points, as well as returning the most similar precedent cases to your case. In this example case with our client, Ms. Roberts, it's a $133,000 case, most likely award value, if handled in Miami-Dade County in Florida as its jurisdiction. Attorneys have told us knowing case value is highly important, but what's also important is being able to defend the value of that case with the counterparty, the insurance company, the mediator, the arbitrator. And so for every case, what you see here is our proprietary similar case model returns the most similar cases to your case, always in the same state, often in the same county of jurisdiction, with a similarity score based on the totality of the context and the facts of your case compared against precedent cases. As an example, here's a case: Piratino versus Vargas. It's a $175,000 case. Let's move down and look at what we call the case card view. On the left side, you've got our case. This is the Roberts versus Mason case. And on the right side, you've got the most similar cases to your case. And so let's just, as an example, let's find that Piratino case that I just mentioned. And what you can see here is, first, you have the summary view of this case. Of course, it's case number. We are very intentional about never having any of our users or law firms be the next law firm that experiences an adverse effect from bringing in a case reference into legal proceedings that is not grounded in a case number and is not, in fact, a real, actual precedent case. So this case, we have the Piratino versus Vargas case. You have the ability to, in the product, see more information about this case, including the attorneys involved, the law firm, if there are any expert witnesses engaged on the case. You see that as well. And importantly, a side-by-side comparison view of your case on the left. This is our case. And the precedent case on the right, comparing the case across damages, defendants, the injury claims, the liability, nature of accident, and any special circumstances that impacted the value of that case. You may recall earlier in this discussion, I mentioned particular injuries in our case, an L4, L5 disc injury with a nerve damage diagnosis called a radiculopathy. Here we have, in our precedent case, the same C4, C5 disc injury and a lumbar radiculopathy here as well. And so imagine you're an attorney defending the value of this case, and we've just given you in about 10 seconds a spot-on precedent case with a similar injury profile, context, and jurisdiction to allow you to defend your award value. I'll hit on two things very quickly, and then I'll open up for Q&A. What attorneys have asked us for is they'll often say to us, well, you have my case documents, you know the value of my case, you have the most relevant precedent cases. Can you help me automate the next steps in handling this case on behalf of my client? One of the examples that we have built to accomplish that is the ability from the case screen to either create a demand letter or to create a case report very easily within the product. For example, when you create a demand letter on our platform, we do a couple of things that make us unique. One, because we have your case value, we automatically include the value of your case in the demand letter. But importantly, we also include the most similar precedent cases to your case in the demand letter. And so if you recall the Piratino versus Vargas case that we just talked about, you can see that case has already been included in the demand letter, no additional work, an automated process for the attorney to be more efficient in creating a strong evidence precedent point to pursue the higher value claim on behalf of their client. I also mentioned the ability to create a case report, which we see used as well. It looks like this is actually logged out. But what the case report produces is all the information about your case, as well as all the precedent cases in a 25-page PDF report, in a professionally formatted report that you can then send to your client, to the counterparty. We had an attorney recently who sent our case report to a litigation lender in order to provide them with the evidence points they needed to support the approval of a loan decision associated with that case. And so what you can see here is when you have this underlying AI native platform that can understand fact patterns, can understand case value, can understand precedent case fact patterns, it allows you to then begin to automate and extend a number of workflows off of that all serve the interest of helping law firms move more efficiently, and importantly, helping them secure higher values on behalf of their clients. All right, I will pause there and open up for Q&A.
This is great. Thank you so much, Pat. It's very, very cool, I have to say. The first question is from Marcy, and she's asking where you are getting the data from. And if I could just sort of add to that question, if you're taking data from court decisions, final judgments, how much does this reflect also the entire world of cases that didn't get to final judgment, that was settled out of court?
Yeah, so multiple pieces there. One, we have a licensing relationship with a national provider of outcomes. I'd say at this point we're probably 70% verdicts, 30% published settlements. We also pull from the county courts directly. We primarily use that for the ability to show court docket information directly in the product, which I'll show you an example of here. In parallel, we have had a number of plaintiff firms who have said to us, help us form a data consortium in which we share our firm's case history, which in many cases date back 30 to 40 years, in an appropriately anonymized manner, so we can have the case value and precedents enriched by all of the participating firms, because what the plaintiff firms feel is its information asymmetry disadvantage versus the insurance firms, where they're seeing, the plaintiff firm sees maybe 50 cases a month, and the insurance firm, State Farm or Allstate or so on, have a data set that spans across 100,000 plus cases, 1 million plus cases. And as a very recent example, I had a high volume attorney in Florida who came to me and said, I'd like to take the 6 highest volume PI firms in Florida, have us upload our case histories to your platform, and that allows us to then share in precedent-backed case values, so we all have a stronger position against the insurance companies. We have another example of a lead intake firm who we are working with on the opportunity to upload and train on their 400,000 precedent cases in their operating history as well. And so over time, this becomes a mix of the public record and the opt-in operating history. So I just very briefly before the next question, I mentioned the court documents. If you look, for example, here, this is our Puritino versus Vargas case. For higher volume counties, we have the ability for you to actually go directly into the court docket for the case. So, for example, in this case, there are 90 documents here. That gets a bit busy. You have the ability to pull up quite easily the verdict document. So if you want to get to ground truth on a precedent case, for example, the Puritino versus Vargas case, here you can see in the product the actual filled out jury verdict sheet for the precedent case across, in this case, the direct and the general damages, allowing you to really interrogate this case and, importantly, build ground truth confidence that you are working with a real world precedent case, and have all the details you need about the decision making around that case.
Cool. Thank you. So yeah, so one of Benjamin's raising a good question too. He's asking, and what about those cases that were actually not successful? Cases that were brought that were not successful. Where it's not clear what caused the injury. How's that? Accounted for in your model?
Yeah, so the current versions of our model do not predict liability. They are designed to understand the value of this case based on the context and the impact and the injuries for a successful outcome. We do capture and have access to the case in which the defense has been successful, which normally means there's been a $0 outcome. On our roadmap is the ability to not just predict value, but also predict win-loss likelihood as well. The current versions of the model are focused on award value, not prediction on success of establishing liability.
Got it. Okay, so let me just jump to Abid's question quickly, and then I'll get back to Rash's point too. So Abid's, is highlighting that you identified a real pain point, and you addressed already, I think, the question of data quality and data, robustness in light of the fact that insurances and law firm settlements are usually confidential. But what about the question of liability exposure what if you make a wrong prediction? Does that lead to malpractice claims? And
Yep.
and then his other points I will also quickly paraphrase. So on distribution, how do you sort of relate to the larger platforms that can, as he points, it can crush standalone tools, and what how do your terms of service kind of account for the kind of try to limit your risk, that you're not like that this is just a decision support system and you're not promising 100% accuracy and so on.
Yeah, so that's an important distinction to make. We are, as you mentioned, we are a decision support tool for licensed attorneys and law firms. We have not, for example, pursued a alternative business structure that may allow us to operate as an investor-owned law firm. We license to licensed attorneys, and we are a tool for them to use to more efficiently understand when to accept or decline or defer cases, as well as moving quickly to create the demand and ultimately either settle that case or decide if the settlement value is insufficient to move forward and file and litigate that case. But we are not autonomously making legal decisions on behalf of clients. We are a support tool for licensed attorneys. To the question on larger platforms, we pride ourselves on our ability to execute quickly and to be unencumbered by the technical debt that can often lead to slower pace of execution by larger established players. We see ourselves as a best-in-class solution for this area of legal work. As an example, we are in process with a high-volume firm who has said to us, "I would like to pair what you do with additional legal tech startups for medical chronologies and initial treatment and diagnosis to pull together best of breed across each of the areas of handling a case." And so what we hear from the market is less of an appetite for slower moving incumbents and more of an appetite for demonstrate that you're best of breed in what you do. And that's what tends to attract the interest.
Mm-hmm. Cool. So Raj is asking, how do you ensure that all leads are integrated into the portal, like phone leads and web leads? So you're not necessarily like trying to bring in leads to firms, or are you? Is that sort of part of what you're?
Yeah.
So
So you have the ability as a customer or as a customer of our product, you have the ability to replace the intake form on your firm's website with what we call our AI smart intake form. If you've ever been to a personal injury firm's website, they're very often WordPress sites with fairly basic web forms, name and phone number and what happened. And then those leads will typically either go into email or will sit in a CRM system until a member of the firm's able to go in and work that lead. In our case, if you deploy our AI Smart Intake form on your firm's site, a minute after that consumer leaves your site, you'll have the case value, the precedent cases, and a full case report in your inbox a minute after that consumer leaves your site. As a real-world example of the pain point that this helps solve, I spoke to a national level lead firm that told me they gave their call center the day off on Thanksgiving. Call came in Thanksgiving evening, high value opportunity, was taken by the after hours answering service. They followed up with that lead the morning after. That lead had already signed with the competition. And so that just goes to show you the importance of being able to accurately and quickly understand value on new leads. Just as another example, we had an attorney who told us, I could be anywhere in the world, and if you guys send me an email that says there's a $173,000 lead in my inbox, I'm stopping what I'm doing. I'm calling that client, and I'm sending out an engagement letter. So that sort of those anecdotes for us is reinforce the value of being able to move as efficiently as possible to identify when a high value lead has come in.
So we're already a little bit over time. I just want to, and I saw Dave has been answering some of the questions that people ask in the chat. But how do you sort of differentiate from other players like, Eve Legal and Supio?
Yeah, so what we typically see is other legal tech players tend to have a center of gravity around certain things. For example, Even Up has a center of gravity around the demand letter. Supio tends to have a center of gravity around medical chronologies. Where we like our position in the market is really before you even get to medical chronology or demand letter, the first question you're asking is, should I take this case in the first place? What is this case likely worth? In our view, that makes us one of the first legal tech products that are used when a new case comes in, and then allows us to offer additional value in the automation, in the analysis of the documents, perhaps it's the demand letter, it's a case report, etc. And so we tend to like our position as one of the first products that a firm uses for a new case. And then that gives us the ability to earn the right to be used in downstream portions of the case management workflow as well.
Yeah. Okay. Well, maybe I have one more question. So based on my own experience, it appears to me that, firms have their already their sort of homegrown kind of algorithms in a sense for making a decision, even if not in a computer system, but they have a way to determine whether to take a case or not. And I found it, I was surprised that, in theory, we have this, this contingency fee system in the United States where technically this should give anyone access to legal representation. But then it's also the case that firms will only take cases that are of a certain value. You empowering the firms to make that decision even more clearly, so they don't make any errors, right? So with your system, they can get a better prediction, right? But it doesn't necessarily give people who have injuries that, maybe less than, $100,000 or 50 or whatever the threshold is, right? Doesn't necessarily give them access to attorneys, right? I was just wondering if you have any thoughts there. If eventually, there will be ways for, and maybe it's maybe it's just, self-represented litigation folks who can represent themselves and with all the tools that are available out there. But that's, I think, that's an issue too, I think.
Yeah, I think there are a couple things there. One, there are PI firms that specialize and may filter on a higher value. For example, you run across a medical malpractice firm that will only handle cases that are above a $1 million award opportunity. One of the things that we expect to happen is as our platform and other legal tech platforms allow cases to be worked more efficiently with less manpower, it does make it easier for firms to take on cases that may otherwise have not been worth the contingency fee investment of time, the paralegal's time, the research time, the document management time, the ability to automate the workflow around handling of documents, case value, creation of the demand, etc. That lowers the cost, which lowers the risk of taking on lower value contingency cases, which we hope has the effect of allowing more important to the individual, but less high value for the firm cases to be taken on, because the time investment and cost risk of taking on those cases becomes minimized with the AI native and automation pieces available now.
Cool. Well, that's an exciting vision. So that'd be great if that was one of the outcomes. So, well, great. Well, Pat and Dave, thank you so much for joining us. Thank you for telling us about Predict.Law. It's really cool. It's impressive. And if folks wanted to reach out, if they had any follow-up questions, what's a good way to, perhaps you could put your email into the chat. Or...
Yep, it's easy. It's I'm at Predict.Law. So PAT@Predict.Law.
All right, wonderful. Well, again, thank you. A quick round of applause. And on behalf of everyone. And good to see you. And we'll see everyone in early February. Also, very soon we'll be putting the agenda for our Future Law Conference in April on the website. And so check it out. Hopefully you will join us here in April. We're planning a really exciting program. But anyways, well, good to see you all. Thank you again.
Thank you.